Today, we're diving into a really high-stakes battle that went all the way to the Supreme Court. We're talking about Abbott v. League of United Latin American Citizens. This case is a fascinating look at political power, how voting maps get drawn, and a huge question of fairness in Texas. So, let's break it all down. And this really gets to the heart of the whole conflict, right? When a state is redrawing its voting districts, where exactly is the line? Where does trying to get a political edge cross over into illegally sorting voters based on their race? It's a super complex question, and it's one the courts really had to wrestle with. All right, let's set the stage here. Now, usually, states redraw their electoral maps once every 10 years, right after the census. But back in 2003, Texas did something highly unusual. They decided to redraw their congressional map right in the middle of the decade. And as you can probably guess, that move immediately kicked off a massive legal firestorm. Just look at how fast this all went down. In early June, top officials are on the record saying, nope, no redistricting on our radar. But then a letter from the Department of Justice shows up, and just 2 days later, the governor completely changes his tune. By the end of the summer, boom, Texas has a brand new map. So what in the world did that letter say? Well, this was the big turning point. The letter came from the Department of Justice under the Bush administration, and it claimed that 4 of Texas's districts had legal problems specifically tied to their racial makeup. You see how this reframed the whole thing? Suddenly, what looked like a political power play was being presented as a legal necessity. It gave Texas officials the justification they were looking for. So the DOJ's letter really zeroed in on something called coalition districts, which are pretty common in diverse states like Texas. But the letter claimed, incorrectly it turned out, that these districts were somehow illegal and had to be corrected. This official directive, focusing so heavily on racial composition, became a critical piece of evidence when this all ended up in court. With the new map officially in place, a lawsuit was filed almost immediately. And in the courtroom, the case boiled down to 2 totally conflicting stories about what Texas was really trying to do. Was this all just about politics, or was something else going on? Was it about race? The challengers argued that this was a textbook case of racial gerrymandering. They didn't dispute that the ultimate goal was to gain a partisan advantage for Republicans, but they said the way they did it was unconstitutional. They argued that by using race as the main tool to draw these new districts, Texas had clearly violated the Constitution. And the challengers brought some pretty powerful evidence to the table. For instance, they pointed to one of the redrawn districts that was engineered to have a Black voting age population of exactly 50.2%. The argument was, you don't hit a number that precise by accident. It strongly suggests the mapmakers were using racial data with almost surgical precision. So after a massive 9-day hearing where they heard all the arguments and looked at all the evidence, the district court actually sided with the challengers. The judges found there was substantial evidence that race, not politics, was the #1 factor in drawing the map. And because of that, they issued an injunction stopping Texas from using it. But of course, the fight was far from over. Texas immediately appealed to the Supreme Court. They asked for something called an emergency stay, which is basically a request to press pause on the lower court's order. They wanted to go ahead and use the disputed map for the upcoming elections while the legal case continued to play out. And this is where we get to the core of the Supreme Court's split decision. On one side, you have the majority, which granted the stay. They said the lower court should have started with the assumption that the legislature acted in good faith. They also hit the challengers for not providing an alternative map. But on the other side, the dissent fired back, saying, hold on, you're only supposed to overturn a lower court if there's a clear error. And the direct evidence here, like that DOJ letter, is just too strong to ignore. Now, this clear error standard is a really important legal concept here. It sets a very high bar for an appeals court to overturn a lower court's findings. Essentially, they're only supposed to step in if it's obvious a definite mistake was made. The dissent's whole point was that the majority was ignoring this rule and basically redoing the job of the fact finders, which isn't its role. Justice Kagan's dissent was incredibly sharp, and this quote really captures the heart of it. This idea that the court's decision wasn't just some abstract legal ruling. It had very real consequences for millions of voters, and it effectively ignored the detailed, on-the-ground work of the lower court. Okay, so the Supreme Court makes its move. What happens next? What did this emergency order actually mean, both for Texas and for the rest of the country? Well, the immediate impact was crystal clear. Texas was going to use the very map that a district court had already ruled was an unconstitutional racial gerrymander in the next election. Even though the legal case wasn't officially over, the new district lines were locked in for that election cycle. But this ruling also sent some major signals way beyond Texas. For one, it suggested that it might be getting harder for challengers to prove racial gerrymandering. It definitely reinforced the idea that you'd better show up to court with an alternative map. And it showed the court is willing to jump into these election fights quickly. As the dissent warned, this could actually encourage states to pass controversial maps closer to an election, gambling that the courts will be hesitant to step in at the last minute. All right, now, just for a moment, let's look at this from a different angle. We're going to analyze the case from the perspective of a hypothetical 10th chair on the court, focusing strictly on the evidence that was presented in the record. So, from this 10th chair view, you could make a pretty strong case for denying the stay. First, you'd defer to the district court, the ones who actually sat there for 9 days and heard all the testimony. Second, you'd probably give more weight to the powerful direct evidence of racial motive, like that DOJ letter, than to the inference you're supposed to draw from a missing alternative map. And finally, you'd have to account for timing. The state basically created its own emergency, and you wouldn't want to reward that. And that really leaves us with this huge, lingering question. When partisan goals and racial data are so tangled up, maybe even intentionally blurred, who has the power? And frankly, who has the responsibility to unravel it all? And just a reminder, this is for entertainment and educational purposes only. This is not legal advice.